All right. Hello, everyone. Welcome to this special webinar. My name is Sam Brooks. I'm the Director of Public Policy at the National Consumer Voice for Quality Long-Term Care. We're really excited to have you all in here as people trickle in. We are having this webinar today to talk about recent updates to the Federal Nursing Home Surveyor Guidance. We're excited to have you here. Let's get right into it. Next slide, please. So hopefully you know about the Consumer Voice, but if you don't, we are the leading national voice representing consumers and issues related to long-term care. We advocate for public policies that support quality of care and quality of life responsive to consumer needs in all long-term care settings. We empower and educate consumers and families with the knowledge and tools they need to advocate for themselves. And we train and support individuals and groups that empower and advocate for consumers of long-term care. And we promote the critical role of direct care workers and best practices in quality care delivery. Next slide, please. So just some housekeeping points here. This program is being recorded. We will share it later at a later time, pretty soon, right after it concludes. So you will be able to watch it again. To ask questions, please use the Q&A feature. It's on the bottom next to chat. You can use that chat feature, though, to submit comments or respond to questions or talk amongst yourselves. But please, if you do have a question, please put it in the Q&A. We should have time to answer those questions at the end. Link to the resources, including anything put in the chat box and the slides, will be found at theconsumervoice.org. So you can get all of this later after the webinar ends. Please, next slide. We are really excited to have three wonderful folks here today to walk us through this guidance. First up will be Eric Carlson. Eric is the Director of Long-Term Services and Supports Advocacy at Justice and Aging. After that, we'll have Toby Edelman, who's a Senior Policy Attorney at Center for Medicare Advocacy. And then we'll have Lori Walsh, who's at Consumer Voice, and she's a policy and program specialist. So we have a nice lineup of heavy hitters today to walk us through this. Next slide, please. So why we're here. On November 18th, of last year, CMS released new guidance to state surveyors. This guidance really it governs how state surveyors should be enforcing the nursing home rules and laws, and is really, as many of you know, very detailed down to the minutia guidance about how these so important rights and various regulations should be enforced. This update included a lot of great and important stuff, including prohibitions on third-party financial guarantees, inappropriate transfers and discharges, unnecessary use of psychotropic medications, and the misdiagnosing of residents with schizophrenia. And then just recently, on January 15th, new language was added, which we'll go over, regarding nursing home staffing data and payroll data. So lots of great stuff in here. And so why don't we get right underway? I'm going to turn it over to Eric. Thanks, Eric.
Thank you, Sam. So on today's webinar, I'm going to address two topics: the financial guarantee issue and then also the informed consent issue. Just a note on resources: Justice and Aging put out a issue brief solely on these two issues on December 5th of last year. So you can take a look at that for some additional detail on the topics I'm presenting on today. The first is this no financial guarantee rule in nursing facilities. The federal nursing home reform law applies to all federally certified facilities across the country. And under long-standing law, going back 30 plus years at this point, a nursing facility is prohibited from requiring a financial guarantee from a third party, usually a family member or a friend. So they can't have a adult child or a neighbor or fellow church member or somebody take on responsibility for nursing facility expenses under the federal law. What the facility can do is have that person act as an agent, which, and the distinction makes sense because it's not fair to expect someone to co-sign because how much are they potentially liable for? We're talking about nursing home expenses. If you co-sign a car, you know what you're responsible for, whatever the price of the car is. But if you co-sign on a nursing facility admission agreement, what's the bill going to be? 10,000, 50,000? You see bills of this size, and a third party shouldn't be stuck with financial obligations like that. People should be able to enter a nursing facility without having that kind of financial obligation being imposed on family members and friends. So that makes sense. And then a facility is allowed to have someone sign as an agent because, as we all know, a lot of nursing facility residents aren't capable of handling their own financial affairs due to dementia or some other condition. So someone needs to act on their behalf. But in doing so, that representative should only be obligating the financial resources of the resident. So, common example, the adult child is an agent under a power of attorney, signs the admission documents as an agent, and in doing so, obligates the resident to pay for nursing facility expenses, but doesn't obligate the adult child because he or she is just acting as an agent. So that's a longstanding law. We can go on to the next slide, please. And it gets a little more complicated here because facilities have forever, really from day one, back in 1990, 1991, have tried to evade this provision in a variety of ways. And most commonly these days, a nursing facility in its admission agreement doesn't require a financial guarantee, but sets up something that attempts to accomplish the same thing by most commonly having we'll just say what they'll call a responsible party in the agreement, have that responsible party agree to use the resident's money to the extent the person has access to the resident's money to pay the facility's bill, and then also to take all necessary steps to arrange for Medicaid eligibility as appropriate. And then, just assuming down the road the bill isn't paid, then the nursing facility files suit against the third party, the adult child, and says in its defense, well, this isn't a cosigner. What we're doing is we're suing this adult daughter, let's say, for her breach of the admission agreement. She was obligated to pay us, to use the resident's money to pay us, or to make sure that there was Medicaid eligibility. That didn't happen. And so we're filing a suit against the daughter. So as you can probably sense, it feels a lot like an end around the nursing facility law because the facility is trying to accomplish the same thing. The nursing facilities often lose on that basis. Occasionally they'll win, oftentimes because the family member did take inappropriate action and handle the resident's money inappropriately. But it's been a bad state of affairs. It's hard to generalize about the court decisions because they're all over the place. But there's good information here on the CMS front. We can go on to the next slide and get into the surveyor's guidance that addresses it. And what the surveyor's guidance does is make it clear that this, we'll say Weasley language, the tricky language, the end around language, actually should be considered a violation of of the federal law. The nursing facilities are trying to accomplish the same thing, so it shouldn't be allowed. Here's the language from the surveyor's guidance. Note that the admission agreement, quote, can be non-compliant even if it does not specifically reference a guarantee. Any language contained that tries to hold a third-party person responsible would violate this requirement. So really directly applies to the example that I was just talking about over the last couple minutes. The nursing facilities trying to sneak around the federal law, and the federal government here is saying, no, that's not going to work. We're going to consider this non-compliant because it accomplishes the same thing. Next slide, please. And then here's some examples. So that the CMS will consider violative. Language that holds both the resident and the representative jointly liable. This could be considered a violation. Next slide, please. This one really addresses the example that I was talking about just in the last couple minutes. So, for example, holding the person liable for failing to apply for Medicaid in a timely and complete manner. And then next slide, please. And then language that tries to hold this, let's say, responsible party liable because that person did not provide accurate financial information. So very positive development that expresses CMS's opinion that all this language on the margins is violative because the facility is really violating the federal law, even though the facility is trying to be a little cute with what's a guarantee and what's not. Next slide, please. And then just talk about the practicalities. It's one thing just to note from an advocacy perspective here, you don't want to be in court if you can help it, right? These are all good arguments. The easiest way to avoid this problem is not to sign these agreements in the first place. So look for them, cross them out, explain how these provisions violate the law in a way that I've just described. You're in a particularly powerful position if the resident is already in the facility, because then you can say, well, I'm not signing this, and the person can't be evicted because they're already here, and let's go forward on this basis. For better or for worse, I have a personal anecdote on this issue. I broke my leg in mid-December in a bike accident, and was in the hospital, and then was after a couple had surgery, and then was transferred to an inpatient rehab facility. And so I'm in this medical transport on the way to the rehab facility. The phone rings, and the phone ring says, hello, this is so-and-so admissions coordinator at inpatient rehabilitation facility. I'm going to email you. Can I have your email address? Because I'm going to email you the admission agreement, and you can electronically sign it before you get here. So I got enough experience at this point, not being injured, but with these sort of issues to say, no, I'm lying on my back on a medical transport. I don't think I'm gonna get a document from you over my phone and electronically sign it. But that's just I think representative of how this sort of thing plays out sometimes. And there's some real issues with these electronic DocuSigns. The big message here, though, is like, be cautious at the front end. You can use these arguments if you're in court and if you're being sued, and that's great, but it's better to use these arguments on the front end to avoid signing. And so be cautious about things, and don't underestimate your authority to just say, no, I'm not signing this. This is improper. You do not assume that if you sign it, oh, everything I'm sure will be fine. It may not be fine. And even if it's creates some personal tension, a little bit of tension, a little bit of controversy at the front end, it is worth it to protect yourself. And then next slide, please. This is a second topic. And this is a piece, Lori's going to talk about this a few minutes later with more details on the medication, but I wanted to just address a piece of this. It's something that I mentioned is covered in the Justice in Aging issue brief. For medication, you need informed consent for any kind of medical procedure. It's not just a doctor's order, it's the is the person saying, I can consent to this. And that is oftentimes been ignored in nursing facilities. You can go to the next slide, please. For medication, back to my direct service days, I ran into all sorts of these situations where adult children come to me and say, um, we don't know what's going on, that this medication's being administered and we don't know what it is. It's what should we do? And the problem there is that too often in these settings, it's just assumed that these are doctors' decisions, right? The doctor has issued an order and the facility administers the medication, and nobody ever thinks to ask, well, did the resident agree? Did we give the resident information on the pros and cons of this medication? Did he or she agree to it? And so it's a oftentimes ignored point of leverage. I just encourage people to take this because CMS has reinforced it in these surveyors guidelines. The resident has the right to accept or decline the initiation or increase of a medication. And there needs to be documentation, as stated, good documentation here, that the representatives were informed of the advance of the risks and benefit, the treatment alternatives, and was able to choose the option that he or she preferred. Next slide, please. And the written consent may serve as evidence, but so just again, my own personal feeling is that this is the most powerful way to avoid unwanted medication. Some of the other provisions you end up arguing about what's medically appropriate or not, which is more the province of the physicians. But it's simpler in a way if you're just able to say, no, I have to agree to this. And if I don't agree, you can't administer it. So with that, I will pass the control over to Toby to talk about some transfer and discharge issues.
Thank you. Thanks, Eric. It's interesting to hear your direct experience. I'm really sorry that happened to you, and I hope you've given some more reasons for people to say, I can just say no to that. So thank you. That was really interesting. So I'm going to talk about transfer and discharge for a few minutes now. As we know, the 1987 Nursing Home Reform Law and the implementing regulations set out specific rules for transfer and discharge of residents. They limit the permissible reasons for transfer or discharge. Resident doesn't need the services the facility provides. The resident needs more care and services than the facility can provide. The resident is posing a threat to the health or safety of others. Non-payment of the bill, the facility is closing. The law and regulations also require written notice of discharge, and they give the resident the right to a hearing where the burden is on the facility to prove that a permissible basis for transfer or discharge exists. Despite these comprehensive protections that go back to the beginning of the reform law, transfer and discharge remains a major concern of residents and therefore of advocates and ombudsmen. I want to talk about just the changes that are made in the surveyor guidance that was issued in November. But I encourage people who are dealing with transfer and discharge to look at all of the pages in Appendix PP, pages 191 to 221, because there are some existing protections, not brand new ones, that are very helpful to people. The new protections in the guidance document now are all in red italics. Next slide, please. So the major changes are that, at least according to CMS, that 7 F-tags are consolidated into 2. Now, F-tags are associated with particular regulatory requirements. Reducing the number of F-tags has been a longstanding industry desire. They don't want to have a lot of tags and have 3 or 4 tags for transfer and discharge. This reduces the number of tags. It means facilities will have fewer deficiencies and they will claim they're doing a better job. That's one of the big changes. The new guidance removes the terms facility initiated and resident initiated, and there's some reorganization and revision for the guidance. Next slide, please. CMS describes the purposes of the regulations in two new descriptions of intent, which tell you, and so these are direct quotations, red italics, it's the direct quotation from the guidance. These tell you what the problems are that they've been hearing about, because usually rules, guidance, everything respond to problems that have been identified. So the first part is making sure that residents can return to the facility after they're hospitalized or have therapeutic leave. So just if the facility sends somebody to the hospital, they can't say, well, now you're discharged, sorry, no more rights. No, that if the person is not going to be allowed to come back, that is a notice of discharge, and residents have a right to have that notice and having appeal rights. The second important intent language talks about transferring or discharging residents unsafely or to a location that doesn't meet the residents' needs. Very important issues for us. Next slide, please. Each survey has a team coordinator, and the new guidance says before the survey occurs, the team coordinator must contact the local ombudsman to find out if there are specific residents to talk to who have had complaints about inappropriate discharge. Now, of course, ombudsman can't just disclose residents' names without permission, but this suggests to me that ombudsman should ask residents who, when they're talking to them about transfer and discharge, if they would be willing to talk to a surveyor or to have their story told to a surveyor. The second thing that the team coordinator must do is review complaints and the survey history of the facility with respect to transfer and discharge. Next slide, please. The guidance makes very clear that facilities must have documentation in the record that supports the basis for the transfer or discharge. Facilities can't just say, here, we're discharging this person, causing problems in the facility, unless it's actually documented it in the past. It can't just come up with it at the time of the hearing. So next slide, please. For example, if the basis for transfer or discharge is inability to meet the resident's needs, that has to be documented in the record that the facility tried to meet the resident's needs and couldn't. Next slide, please. If non-payment is the basis, next slide, please. If non-payment is the basis for the discharge, then the facility has to show that it offered the resident the opportunity to pay privately out of pocket or to apply for Medicaid. And the rules also say that if a resident applies for Medicaid, the resident cannot be discharged for non-payment while that application is pending. Facilities cannot discharge residents who appealed a transfer and discharge notice. They cannot discharge them while the appeal is pending. Next slide, please. The guidance also says that a discharge would not be considered appropriate unless there is evidence, documentation again, that the facility considered the caregiver's availability, capacity, and/or capability to perform needed care to the resident following discharge. This is an extremely important statement because we hear from families that they don't have the equipment that their family member needs if the resident is going to be discharged to the daughter's home, for example, or that they don't know how to provide the care that the person needs. They can't give injections. They don't know how to do transfers safely. They can't provide care. It's very important. This is a very important statement, I believe, of the need to make sure that the caregiver is capable and willing to provide the care to the resident on discharge. If not, it's not a safe discharge. Next slide, please. Survey agencies do not cite a deficiency in transfer and discharge based on a resident's receiving a favorable hearing decision. The state survey agency will only cite a deficiency after it conducts a survey. So a rule of practice is probably that if you are representing or working with a resident who is being involuntarily discharged or has gotten a notice about involuntary discharge, file an administrative appeal on behalf of the resident. But in addition, file a complaint with the state survey agency so that the state survey agency knows about this issue and can take action. Next slide, please. It is considered, according to CMS now, a discharge to an unsafe location excuse me, I'm sorry, jumped ahead of myself here. If the state agency identifies a discharge to an unsafe location, an unsafe environment, then the facility's plan of correction either has to say that the resident will be readmitted until they can do an appropriate discharge, or it must coordinate a transfer of the resident to another setting where the resident will be safe. Next slide, please. So discharge to an unsafe location, according to CMS, requires an immediate enforcement action. For example, denial of payment for new admissions. I can't just say, okay, this was not a good safe discharge to an appropriate location. Now we'll wait and see about having a civil money penalty. No, CMS says this has to be treated quickly and immediately by the survey agency. Next slide, please. CMS says that the reasonable person standard is the appropriate standard for a psychosocial outcome. This means that we're not looking only at how the individual resident responded to the discharge or to the concerns of what was happening in the facility, but how a person would ordinarily respond to this, the reasonable person, the every person, even if the resident herself or himself would not respond. Next slide, please. Now, we know there are 4 levels of severity. The most severe level of noncompliance is level 4, immediate jeopardy. Below that is actual harm. These 2 levels of noncompliance account for typically 5 to 6% of all deficiencies. And as a matter of policy, CMS imposes any kind of penalty, usually only if something is called harm or jeopardy. So this is very interesting that CMS is talking about new and additional definitions of immediate jeopardy in transfer and discharge. If a resident is discharged while the appeal is pending, that's immediate jeopardy. If a resident is discharged or the proposal is to an unsafe setting that does not provide the resident's needs, that's immediate jeopardy. And if the facility refuses to allow a resident to return following therapeutic leave and has not given the appropriate notice and appeal rights to that resident, that is also immediate jeopardy. Next slide, please. CMS added new language about actual harm, and this is a facility's refusal to allow a resident to return from an acute care hospital when the facility says it can't meet the resident's needs. Now, again, there has to have been the documentation by the facility that it could not meet the resident's needs at the time the resident was ready to leave the hospital and return to the facility. This is an important expansion of actual harm deficiencies. Next slide, please. Now, this is the only one I wanted to mention that was in pre-existing guidance documents from CMS, but we hear about it so frequently that I just wanted to let you know about this. This part in the guidance says for actual harm is if a resident's skilled rehabilitation has ended, and that essentially means Medicare coverage no longer is continuing. They add, and a Medicaid application is pending, but a resident is discharged anyway, that is actual harm. So we want to look at the immediate jeopardy and actual harm deficiencies. Next slide, please. The facility needs to show that it has taken all the steps necessary and documented them in the medical record for 3 things: that the facility gave information to the receiving provider, that the facility gave the resident information about bedhold policy, and that the facility completed a discharge summary. This is the F628, which is all of the process requirements for transfer and discharge. Next slide, please. So there's new language about immediate jeopardy for these process requirements, and this is a facility's failure to tell the receiving facility that the resident that this transferring facility is sending had a stroke, was on blood thinning medication, and then the receiving facility did not administer blood thinning medication because it didn't know about it. that is immediate jeopardy as well. So what I would say about the new guidance in summary is that there is a repeated discussion of unsafe location. And now many of us had been trying to get CMS to say discharge to a homeless shelter is automatically and always an unsafe location. CMS didn't take that step, but it did say that an unsafe location is not appropriate. People would need to talk about what the location is and why it is inappropriate. Make the proof for that and for hotel rooms. We hear that a lot. I just heard from a resident this morning. The facility told her they'd pay for a hotel room for 8 days. And then what? You know, not a good location for discharge. So that's one thing. Repeated discussions of unsafe location. There's a lot of requirements about documentation in the record as the basis for transfer and discharge, and it has to be in the record before the discharge is requested or ordered. And there are additional examples of immediate jeopardy and harm. So I think with the ombudsman being contacted about transfer and discharge and more examples of jeopardy and harm, I'm hopeful that this will make a difference and maybe make some of those rules that have been there since the law was passed in 1987, make them more of a reality for people. Now I'm going to turn this over to Lori. Thank you.
And thank you so much, Toby. I can say certainly as a local long-term care ombudsman that the better protections that residents have when it comes to discharge, the better for everybody. So I'm really happy to see all that. Okay, so this section is the nursing services and payroll-based journal. And Libby, if you can move to the next slide. So this was new language that was added, effective, issued on January 15th. So they made revisions to the revised guidance, and they added this. So new definitions, they defined licensed nurse, which is any nurse that's requires the successful completion of a National Council licensure examination. At a minimum, this includes a LPN, a licensed practical nurse, or an RN, a registered nurse. They also added the definition to charge nurse, and they describe this as a licensed nurse with specific responsibilities designated by the facility. And they also defined scope of practice, which they say in the definition are the practices that a qualified health professional who's deemed competent to perform and permit certain duties. They added examples that may identify potential insufficient staffing, and this seemed to be a theme throughout the section as well as the rest of the sections that I looked at. And they also clarified that compliance with state staffing standards does not necessarily determine compliance with federal staffing standards. Examples that may point to insufficient staffing: falls or weight loss, dehydration, pressure ulcers, elopement, and resident altercations. So I noticed when looking at the guidance that there was a lot of work put into being very, very clear about different examples to make sure that it's understood what they're talking about. All right, next slide. Payroll-based journal, as we all know, we refer to it as PBJ, is the staffing data. They added new language that requires the team coordinator in preparation for the recertification survey to obtain the PBJ staffing data report and to look at that data that's submitted by the facility. They also specified that this data must be used at least on every research survey. It specifically said that every team member needs to be aware of the offsite preparation information prior to entering the facility. And then they also provided probes to determine if the absence of a licensed nurse caused harm or placed residents in immediate jeopardy. There was also in here, actually, can you go on to the next slide? Thank you. Chemical restraints and unnecessary psychotropic medications. So this language was added to the guidance for a number of citations, and there are 8 citations. And while reading this, they made it very clear that they're looking very hard at targeting chemical restraints and trying to be very, very clear on various definitions. So they added the definition of psychotropic drugs and unnecessary drugs. They are highlighting that residents are not to be given psychotropics unless the medication is necessary. And they specify throughout the guidance that part of what they consider medication being necessary is that it's diagnosed and documented in the clinical record. They talked about gradual dose reductions, which they refer to as GDR, that must be used to discontinue drugs. And they specify limits for the use of PRN orders. And they specified a limit for 14 days for its use. They also included a lot of reference material, which I thought was very interesting. And they specified in this section, as well as the rest of the guidance, that residents are only to use the psychotropic meds when other interventions fail. Next slide. The chemical restraints definition was expanded, and I actually wrote it down so I could read it. And what the new definition says is it refers to any drug that's used for discipline or that makes it more convenient for staff to care for a resident and not required to treat medical symptoms. This includes instances when a psychotropic medication may be approved to treat certain symptoms. However, non-pharmacological interventions should be used or attempted unless clinically contraindicated because they are less dangerous to a resident's health and safety. In these instances, a medication would be deemed not required to treat a resident's symptoms because a safer alternative should be used. And then they provide an example. So they certainly are spending a lot of time in making sure that we're all on the same page about what they mean when they're talking about chemical restraints. They also included specific language regarding the reduction of chemical restraints. And I highlighted what they say here. Psychotropic medications have the potential to create symptoms consistent with sedation, creating convenience for staff, which would be considered a chemical restraint. And then they cite the level that it should be cited at if it is not addressed. Can I have the next slide, please? This is part of that same FTAG 605. So this is like a subcategory within that. And what they did in this section is just reaffirm the rights of residents to be free from physical and chemical restraints for purposes of discipline and convenience. They defined convenience and discipline, and then they provided examples of the effects on residents when psychotropic medications are used for staff convenience. And you can see that I've listed off the different examples that they've used. Next slide. There are comprehensive assessment and behavioral interventions. Throughout this section, they really were trying to drive home that documentation must be used to support the need for the medication. So they also talked at length about the non-pharmacological approaches that must be attempted. So the language that's used now really states that within the documentation, it needs to relate to the resident's physical, behavioral, and mental and psychosocial signs and symptoms. And that information has to be used and documented whenever there's any initiating, maintaining, or discontinuing medications. Over and over again, I saw that the resident's medical record must include the documentation and the rationale for chosen treatment options. And the facility also needs to ensure that the resident's behavior is not due to some other factor. And they had a whole list of them. I just put on the slide that pain is an example. And then they also listed off examples are provided of circumstances that warrant an evaluation of a resident's medical condition. And some of those would be admission or readmission, an irregularity that was identified in the pharmacist's medication regimen review, a new medication order as an emergency measure, and certainly also in a situation where a resident is experiencing an acute medical problem and the phase has stabilized, but staff and the prescriber need to also consider whether medications are still relevant. Next slide. These next two slides were about determining the necessity to use the psychotropic medications. And I really enjoyed them because they really tried hard to clarify situations in which it was appropriate to use psychotropic medications, as well as situations where it was not. So the key highlights I wrote in this slide: a diagnosis alone does not warrant the use of psychotropic medications. They provide examples of side effects when psychotropic medications may not be warranted. And you've seen them in previous slides, but side effects are sedation, depression, confusion, immobility, falls, and hip fractures. They also provide examples of when psychotropic medications may be warranted, and they listed those off as when a resident is a danger to themselves or others, expressions or indications of distress, which is a new definition that they're using, and that means that are significant distress to the resident. Another example in which the meds may be warranted would be if I'm looking at my notes here, if multiple non-pharmacological approaches have been attempted but did not relieve the medical symptoms, which are presenting a danger or significant distress, and or gradual dose reductions were attempted, but the clinical symptoms are returned. The key thing is that there also needs to be appropriate documentation to show that they were trying to do everything prior to putting somebody on the psychotropic medication. Next slide. So, like I just said, documentation to show the rationale for changes in the medication regimen are warranted. This is definitely a theme throughout the guidance that I read regarding psychotropic medications, and also that psychotropic medication should be the last resort. And then they also talked about additional areas of non-compliance that should be included when the facility is unable to provide documentation. And it's a whole section that directs the surveyors to go to different F tags to determine if they're in violation of multiple F tags. Next slide. So this is dose and duration and gradual dose reduction. And again, this all is still under the F tag 605. It includes new definitions. the new definitions, the majority of them are very, very medical. I just highlighted dose because it seemed to be the clearest one to look at. This section, they also talk again about making sure that there is a clinical rationale for continued use of the medication and that it has to be documented. They do provide examples of inappropriate duration, and they also, I'm looking to see if I wrote down some of the examples. So some of the examples of inappropriate duration may include the initiation of a psychotropic medication was indicated, but not used for the lowest dose and the least amount of time. A medication was initiated because of a time-limited condition, for example, like delirium or pain, but there's no documentation showing that the original condition had been monitored. The medication continued to be administered while the original condition may have resolved, or the medication was administered beyond the stop date established by the prescriber without evidence of clinical indication for continued use of the medication. So they're really trying hard to try and close the loop in some of the issues that have come up regarding being misprescribed psychotropic medication. They also added clarification about timeframes and duration of attempts to taper medication. And then the medical record, again, should reflect all gradual dose reduction attempts. Thank you. Next slide. Monitoring and adverse consequences. So this section is, it really like kind of spat out what proper medication management looks like. And it specifically said that it's based in the care process and includes recognition or identification of the problem, need, assessment, diagnosis, cause identification, management, treatment, monitoring, and revising interventions, as well as documenting medication management steps. And then it also provides insight into specific situations. And I just kind of pulled out some of them that I thought were relevant for us. And there are situations when there are multiple prescribers. The continuation of a medication needs to be evaluated. Medications that are prescribed by a specialist or begun in another setting must be documented in the medical record. And then without a documented rationale, the use of the medication may be unnecessary and therefore non-compliant. And next slide. I did also want to say before we move on to this section that in the guidance, they specifically said that the facility's pharmacist and attending must adhere to the requirements of reporting and responding to irregularities. All right, we've moved on to a different FTAG. Comprehensive care plans, mental health disorders, and schizophrenia diagnosis. Next slide. So the theme for this section is all about documentation. It provides examples of insufficient documentation. It lists items that the medical record must include. It's very specific. And it specifically states that the record must include documentation of all of those items. And if they don't, then the surveyor will consider it to be insufficient documentation. And this last piece, which I thought was very interesting, is that it includes quite a few excerpts from the DSM, which describes detailed diagnostic criteria for these 3 types of disorders. And one thing that I thought was really interesting when I was looking at the different examples of insufficient documentation is they wrote a practitioner's note or transfer summary from a previous provider stating a history of schizophrenia, or another diagnosis without supporting documentation confirming the diagnosis with a previous practitioner and or family, and the facility failed to provide evidence that a practitioner conducted a comprehensive evaluation after admission. This section really dove into a discussion or a clarification about situations that where they must have seen a schizophrenia diagnosis, and what was missing was documentation, and that is something that would trigger insufficient documentation or insufficient diagnosis. Next slide. I included this paragraph because it is listed at least twice in the guidance. It says CMS is aware of situations where residents are given a diagnosis of schizophrenia without sufficient supporting documentation that meets the criteria in the current version of the DSM for diagnosing schizophrenia. If the non-compliance causes actual harm or the likelihood of serious harm to one or more residents, or the surveyor identifies a pattern, which they said is 3 or more residents, by the same practitioner prescribing antipsychotic medication for any new diagnosis without a lack of supporting documentation, then the survey team should discuss their findings with their state survey agency for consideration to refer the individual to the state medical board or board of nursing. Next slide. And we are almost done. I'm keeping my eye on the time here. Accuracy of assessments is another F tab. If you could go to the next slide. So there is new language for penalty for falsification of records. This whole section really focused on the data, the minimum data set. So there's new language there that determined if the MDS contained sufficient documentation to support a resident receiving antipsychotic medication. There was clarification on the use of electronic signatures on MDS forms. And there was also language that was added that directs the surveyor to make a referral to the Office of the Inspector General if a pattern, again, 3 or more residents, of inaccurate MDS coding by staff has been identified. Next slide, please. A little section here on QAPI, the quality assurance and performance improvement. Next slide. And this piece added in language around health equity. So a definition was added. And then there was also language that was added regarding health equity concerns when obtaining feedback and data. There was a lot of talk about when the facility is collecting data that they should be including health equity questions, and then using that data, using those factors when making decisions and establishing priorities for their resident populations. Next slide. Pain management. Thank you. Next slide. So revisions were made to align acute, chronic, and subacute pain with CDC definitions. There was new language that was added about the use of opioid treatment. There was language regarding opioids inserted throughout this section. And they specifically said that opioid treatment for pain needs to be appropriately assessed and individualized for each resident. One thing that they did highlight is that clinicians may consider prescribing immediate release opioids instead of extended release and long acting. And they had resource links on opioid use throughout this whole section. Thank you. Next slide. Oh, and this is the last piece. Thank you. Can you pass on to the next slide? And they incorporated the 2 CMS memos about infection prevention. That's the first memo. And then the second one is about COVID-19. And they incorporated the language into Appendix PP. And I think that brings us to the end of our webinar here.
Well, thank you. Not necessarily at the end. We might have a couple minutes for some questions. Can you go to the next slide, please, Libby? At this link, you can find a summary of what we went over today. Eric also shared Justice and Aging's summary. This is Consumer Voices summary that goes through each change and gives some relevant language to that. Next slide, please. This is how you can connect with us. I wanted to say there a couple times the question came up about what does this apply to? Will this apply to assisted living facilities? Will it be does it apply to hospitals? No, this applies solely to skilled nursing facilities, nursing homes that receive Medicare or Medicaid dollars. So none of what we went over today, unfortunately, will be relevant to assisted living facilities or other facilities. Certainly they may be law for that, but these guidance today did not cover that. We do have about 4 minutes. I think we have time for maybe 1 or 2 questions. Toby, Toby, if you could come back for us. There was a question about the elimination of facility initiated and resident initiated and can you talk about the elimination of this language? Is it good? Is it problematic? What do you think?
Yeah, I don't really understand the significance of it. I mean, if a resident wants to leave, a resident is not a prisoner in a nursing home and can leave at any time against medical advice or otherwise. So I'm not sure that it makes makes sense to talk about resident initiated, because we're talking about when facilities are saying they want to have a resident leave. I don't know. Eric knows a lot about transfer and discharge. I wonder if he'd have a different position on that.
If I had to choose, I'd say it's a positive. I think that the existence of that distinction gave a little wink to facilities to claim, well, this was resident initiated, right? Even if the facility kind of pushed him out or suggested it was time to go or whatnot. So just like Toby said, that people know how to leave if they want to, but having this distinction floating around gave a little bit of a green light for facilities to say we didn't have to comply with these requirements because it was supposedly resident initiated.
I think that's exactly right, Eric. I mean, what the person wrote me today and what we've heard is that they'll say, well, how would you like to go to a hotel for a couple of days? And the resident says, okay. Well, then they'll say, well, then resident was happy to do it. We weren't discharging them. They voluntarily wanted to do it. So yeah, I think it's better. This is one of the better changes.
Sam, if I could add to the elimination of the distinction does make a difference for ombudsman programs, and the fact that now the facility is required to send all discharge notices to ombudsman programs, where before, where there was the distinction, they were required to send the facility initiated discharges. So ombudsman programs, as you're looking at the receipt of discharge notices, expect that you'll be getting more, and certainly it would be in your best interest to have processes for reviewing and evaluating them. And so maybe that's something you can work on with your state ombudsman program.
Okay, thanks, Lori. Unfortunately, we don't have more time for questions. You can go to our website and probably get most of your questions asked or answered, excuse me. I want to thank Toby and Eric and Lori for their wonderful presentation. There was a lot of information in this, and you really broke it down into simple terms for us. Hopefully this will be make a big impact in residents' lives and also in the work that you all do. So thank you all for attending today. We're grateful to you all, and we'll see you next time at the next webinar. Take care.
Thanks. Thank you.